Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. So first of all, I want to thank all of you who have offered your suggestions over topics to produce to get ready for my vacation. I greatly appreciate that, and you guys have hit some real home runs as far as I'm concerned. Interestingly enough, there's a little bit of what you would call serendipity in some of one, at least one of them. Somebody talked about maybe doing something on debt collection, and I will indeed do that. But as just sort of the way I do what I do, I found a case out of the Missouri Court of Appeals that deals with an interesting aspect in a debt collection case. And so I realized that it's not very well explained and it's probably not very well understood by the majority of people. And I wanted to let everybody know a little bit more about this rather interesting area of the law. So today we have a case of bad lawyering. And by bad lawyering, I mean getting very, very close to the issue of malpractice. The lawyer in this case clearly didn't understand the assignment. As a result of not understanding the assignment, he screwed things up. Before we actually get into the case, let's take a look at something called an assignment and how an assignment might work in a debt collection case, or at least in a loan case. I'll put it that way. Let's say Susie enters into a loan agreement, a loan contract with Acme Mortgage for a $100,000 home loan at 6% interest. Now, at $100,000, 6%, loan term of 10 years, that's an investment that the mortgage company expects to make $133,224 on. And that's a pretty decent amount of profit to make over a 10-year investment at 6%. Very few places where you can get 6% on your money at this point. It seems like a pretty good deal, at least for this particular mortgage company. But mortgage companies often are just storefronts. If you were to go break into it at 3 o'clock in the morning and go rummaging through the place, you wouldn't find stacks of hundreds glued together in the back of a safe because they don't maintain the money themselves. Basically, they are an instrument of a larger company, or they just basically do the turn and burn routine on these kinds of investments. So here's what happens. So Acme makes the loan and writes the check for $100,000 to the actual beneficiary of that. You know, the person that's selling the houses and their realtor are going to get the $100,000. So Acme now has $100,000 invested. But at closing, they get about $2,500 of that back in closing costs, loan origination fees, and that sort of thing, which technically for the investment company or for the loan mortgage company here, it's just pure profit. So the problem for Acme is that it's got a couple of loan originators and a couple of secretaries. It doesn't have computers. It doesn't have file space. It doesn't have somebody who is keeping a running list of all of the accounts going, and it doesn't have somebody who is going to facilitate collecting on this loan if for some reason somebody falls behind. And most importantly, it doesn't want the headache. So since it's gotten back some of what it paid out, it now has an asset worth $133,224 that it spent $97,500 to acquire. So it goes to its favorite source, BMOB, the big mean old bank. And at least when I made my last home loan, it went to a company called Countrywide Mortgage. And Countrywide Mortgage, huge bank, and they buy up all these mortgages. And then they repackage the loans as investment securities. So big mean old bank says, well, yeah, you've got something that's worth $133,000, but it's not worth that today. So we'll pay you $105,000 for it. So they pay a little bit more than the bank or than the mortgage company paid out. And again, they make a nice profit on selling the loan to Big Mean Old Bank. And then what has to happen after they've sold the loan is Acme has to initiate what's called an assignment. And essentially what it says is Acme Mortgage hereby assigns all right, title, and interest and all of its responsibilities in maintaining and servicing this loan to Big Mean Old Bank. It doesn't have to be a long document, it usually is, and it doesn't actually have to incorporate the loan agreement, although sometimes they do. In fact, what often happens is Acme maybe makes 10 loans on the same day and closes on the loans on the same day, and then they have 10 that they want to assign to Big Mean Old Bank. So they do an assignment that lists all 10 of those loans, and away they go, and they get their money, and they're off to the races. So you can kind of see how this all works out for the people at Acme. And over time, the people at the bank who are more happy than they could possibly be to have this asset that's worth a lot of money, and that might be worth a little bit more money if indeed these folks fall behind, or they can potentially get the property if for some reason they default. But this is how things work. And it not only works this way for home loans, it works this way for car loans, and that's where we get into this rather interesting case. So this case comes to us from the Missouri Court of Appeals, Eastern District, and it's Jefferson Capital Systems, LLC, appellant versus Stephanie Rice. And it's appeal from the Circuit Court of the City of St. Louis. The judge's name is Michael Stelzer. And it was decided and filed on August 13th. In this debt collection action, the appellant appeals from the Circuit Court's order denying its amended motion to compel arbitration of respondent, and Stephanie Rice's counterclaim under the Fair Debt Collection Practices Act. In its sole point on appeal, JCAP alleges that the Circuit Court erred in denying its amended motion because JCAP provided competent evidence that arbitration rights were transferred to JCAP from the original debt holder, Drive Time, through a series of valid assignments of contractual rights. So, here's what happened. On April 18, 2015, Rice enters into a retail installment contract with Drive Time Car Sales Company, LLC, doing business as Drive Time, to finance the purchase of a vehicle. She entered into an arbitration agreement with Drive Time also. The contract contained a provision which Drive Time reserved the right to transfer mandatory arbitration rights to any purchaser, assignee, or servicer of the contract. So when you assign something, you're the assignor. When you receive the assignment, like Big Mean Old Bank in the example before, you are the assignee. And in this particular case, the assignee is also the servicer of the contract. The contract included a provision in which Drive Time transferred all Drive Time's right, title, and interest in the contract and vehicle to DT Acceptance Corporation, and then in parentheses, DT Acceptance. This transfer of all contractual rights from Drive Time to DT Acceptance included incorporated arbitration rights, and it occurred on April 18th, the same day that Rice entered into the contract and arbitration agreement. So, at least from the standpoint of Rice, she thought she was entering into a contract with one entity, when in fact there was an immediate assignment of that contract to another entity. So 5 years pass, hard times hit. In January of 2020, JCAP filed a deficiency and repossession suit against Rice, seeking to recover over $13,000 and the purchased vehicle. In September 2020, JCAP obtained a default judgment for $13,741.30 against Rice, which was subsequently set aside, and Rice was given leave by the court to file a responsive pleading. Rice then filed an answer and counterclaim under the FDCPA against JCAP. In response, JCAP filed a motion to compel arbitration of Rice's counterclaim. Now, what's interesting here is that usually you cannot split your causes of action. And so when they bring an action to essentially recover the car and get their deficiency judgment, they can't then essentially enforce the arbitration agreement, because even though there is a mandatory arbitration provision, they have come to court voluntarily to seek relief. Now, it could be that the lawyer just didn't pick up on that, and it could be that the lawyer just didn't understand what they were doing. JCAP could very easily have taken her to arbitration to get the vehicle back, but that's not what happened. They went into circuit court. And most likely the reason they went into circuit court is because they were dealing with a debt collection law firm. And as a result, to be a good collection lawyer, you don't have to be a smart lawyer. You just have to be an avaricious one. And as a result, as I mentioned maybe before, they don't attract the highest quality help in this particular profession. So now let's go back to the opinion. Now, in order to enforce these arbitration rights against this nice lady, one of the things they'll have to do is they will have to show that the entity here, JCAP, is in fact entitled to collect on this loan. So here's how they try to do that. First, they take and they file an affidavit with the court. And then it's in support of its assignee status, JCAP submitted an affidavit from JC, the custodian of records, for drive time, and an additional corporation called Bridgecrest Acceptance Corporation. In the first affidavit, JC identified Bridgecrest as formerly known as DT Acceptance Corporation. Other than that statement, the first affidavit did not contain any further statements or exhibits pertaining to the relationship between DT Acceptance Corporation and Bridgecrest. The first affidavit stated that the Drive Time assigned the contract and arbitration agreement to Bridgecrest on April 18th, the same day that Rice executed the contract and arbitration agreement. Additionally, JC attested that JCAP purchased accounts from Bridgecrest, referenced an attached bill of sale, but JC did not authenticate or attach an account schedule specifically showing that Rice's contract and arbitration agreement was one of the assigned accounts. So the circuit court issued its order denying JCAP's motion without prejudice, which means, hey, you can bring this motion again. They said the circuit court found that JCAP had not provided competent evidence of the links in the assignment chain from Drive Time to JCAP. In particular, the circuit court concluded the first affidavit and accompanying evidence fatally omitted the link in the assignment chain from Drive Time to DT Acceptance. JCAP filed an appeal. In our memorandum, the Eastern District, accompanying our order, we held that Drive Time explicitly assigned its rights under the contract and arbitration agreement to DT Acceptance Corporation the same day the contract was formed. Therefore, Drive Time could not have subsequently assigned and transferred its rights to Bridgecrest because it no longer had any rights to transfer. So they remanded the case back to the circuit court. So to make this a little more clear, here's what they proved. Drive Time assigned the thing to Bridgecrest, and Bridgecrest assigned it to JCAP. Except that wasn't what happened. What they should have proved was Drive Time assigned it to DT Acceptance Corporation. Then there was a name change from DT Acceptance Corporation to Bridgecrest. Then Bridgecrest assigned it to JCAP. And that would have been a proper showing of the chain of title of the assignments in that particular case. And so the Court of Appeals was absolutely correct when it said, essentially, you failed in your mission to show the correct assignment. So that, basically DT and Drive Time and JCAP and all those guys decided that they'd take another bite at the apple. So they submitted a second affidavit. In the second affidavit, they cleaned up a lot of things that they'd missed in the first affidavit. And the court goes through all of those. It said it alleged that JC was the custodian of records for the related entities of these corporations, and then it laid out, based on her review of the business records kept by Drive Time Car Sales, Bridgecrest Credit Company, and their affiliated entities, what the status was. But Missouri has a very specific way to admit business records by affidavit. You have to show the things that are required in the business record affidavit statute. And here is what the affidavit is, or what the business record statute requires. A record of an act, condition, or event, insofar as relevant, shall be competent evidence if the custodian or other qualified witness testifies to its identity, the mode of its preparation, and if it was made in the regular course of business, at or near the time of the act, condition, or event, and if, in the opinion of the court, the sources of information, method, and time of preparation were such as to justify its admission. Now, the purpose of this is to take it outside the operation of the hearsay rule. It's no longer hearsay, it's competent evidence. So you have to meet all of the standards set forth in that particular affidavit statute. And so the appellate court says, look, your affidavit generally alleged that the attached exhibits were kept in the regular course of business, that's a requirement, made at or near the time of the act, event, condition, opinion, or a diagnosis set forth in the record. Again, that's there. The second affidavit also alleged the records were exact duplicates. The second affidavit did not set out with specificity the mode of preparation of the documents, the connection of documents maintained by the related entities, and any alleged transfer of such records to these related entities, or where the records originated from, or who exercised control over maintaining these business records prior to DT Acceptance name change to Bridgecrest. So, in essence, they just failed completely to adhere to the requirements of the law. We'll have to see how this comes out. I don't know. It's certainly going to be remanded back to the circuit court. And my guess is, between the lawyer who's representing Ms. Rice and the lawyers who are representing the people who are the assignees, they will probably settle this lawsuit at some point in the future, since they have both wasted a whole lot of money on appeals. And that's never a good situation to be in. My guess is these people have spent over $13,000, the amount of money they say is at issue. They've spent more than $13,000 appealing this thing and paying lawyers. Sometimes people get so focused on what it is that they're doing, on enforcing their contractual rights, that they miss the forest for the trees. They have just as much right to enforce those agreements in circuit court, and they would probably have a much easier time showing the assignment if they could bring in the witnesses and then have those witnesses cross-examined. You'd be able to lay out the chain of title fairly easily there. But because they had those by golly rights to go through arbitration, which is supposed to be cheaper, they spent a whole ton of money trying to get those rights enforced, and they lost. Not once, but twice. Sometimes I look at what other lawyers do, and I just wonder if their head hurts when they think that way. Anyway, that's what I have for you today. If you have any comments, drop them in the comments down below. Like, share, subscribe, that stuff we ask you to do. You can always email me at the address above. I'd love to get email. And, of course, one of the things I always ask, if you have the opportunity, do something nice for somebody today. I'm taking my wife to the Olive Garden for lunch because she loves their eggplant parmesan. That's not a plug, by the way. That's just the truth. At any rate, I'm doing my kindness. Please find something to do for somebody, make their day better, and then come on back tomorrow, join me at the beach, and we'll talk about something else fun. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.